My job is to talk a little bit about how the law has responded to this, because we know in Humanae Vitae that Pope Paul specifically predicted that governments would begin to intervene in the most intimate acts of husband and wife. And the international story is the story I told when I was at the USCCB conference. There, the march of coerced contraception, coerced abortion is crystal clear from the 1950s forward. But even in the United States, where we tend to think that we use coercion far less often in these intimate matters of husband and wife, the reality is that there is a great deal going on. And so what I'd like to do in this talk is to talk about how the American government has been co-opted into the debate about natural family planning and abortion as an extension of that versus contraception. Okay, so the story kind of begins in 1873 when the Comstock Acts were passed. Congress passed the Act for Suppression of Trade in and Circulation of Obscene Literature and Articles of Immoral Use, popularly called the Comstock Act. It prohibited distribution for or mailing of any items, advertisement, or literature related to sex, contraceptives, or abortion through the U.S. Postal Service, and Congress had that authority through its power over interstate commerce. Violators of the law would either be fined or jailed. Many states followed suit and passed their own versions. So in 1873, it was clear that the legislative bodies around the country thought that contraception was contrary to the public good and that they should and will regulate based on protection of both public morals and public health. Well, of course, that began to change in the next century. And Margaret Sanger came on the scene. Most of us know her name in association with abortion, but it's important to recognize that in her early campaigns, she actually was an opponent of abortion. She thought that contraception could be separate from abortion, and there are early pamphlets from Planned Parenthood that specifically say that abortion is the taking of a human life. She was opposed to it, but she was very much in favor of contraception. She was in favor of that because of her experience as a nurse in New York City in the 19 teens. And so in 1916, she launched a magazine called the Birth Control Review, putting her in direct conflict with the Comstock Act. And she and her sister, in October of that year, opened the first birth control clinic in America. It was in Brooklyn, New York. It was clearly contrary to both New York state law and the Comstock Act, and so the Vice Squad came in and shut it down. The women were arrested for violating the law that forbade the advertisement, distribution, or sale of contraceptive, and all the condom and diaphragm at the clinic were confiscated. After posting bail, determined as she was, she reopened the clinic, and she was arrested again. Well, that resulted then in a judicial decision regarding her guilt. She was convicted of distributing contraceptives and not being a physician. She didn't fall within any exemption, and sentenced to 30 days in the Queens County Penitentiary in Queens County, New York. Upon release, though, she appealed her conviction, arguing that New York state limitations on the distribution of birth control were unconstitutional. We're beginning to see this drive and the creation of a concept that the Constitution would extend to protect this behavior. Her lawyer claimed that the law infringed on women's liberty by forcing them to conceive more children than they actually wanted, and that while physicians could provide patients with information about contraceptives when necessary to cure or prevent disease, they were forbidden to do so in cases where the pregnancy would be unsafe for the woman. Now, as we go through these cases, I want you to think about the parallels to the development of the abortion jurisprudence in this country. The attack begins that this is about women's health and safety. The Comstock Act specifically, as did the New York Statute, had an exemption for physicians providing contraception in treatment of sexually transmitted disease, but it didn't have one in order to protect the health of the woman. And that was the challenge in the New York courts. In 1918, the New York Court of Appeals, which oddly is actually the high court in New York, it's the New York Supreme Courts or the trial courts and the New York Court of Appeals, it's a bizarre system. But anyway, it's the highest court. And in People versus Sanger, the court ruled that the New York law was, quote, within the police power of the legislature to benefit morals and health of the community. So there are legitimate state interests that would allow us to restrict this, to make such a law as applicable to unmarried persons. As to married persons, the court ruled that physician exemption protected physicians. And here's what they did. They made two expansions in the way they read the statute that varied from legislative intent. The court said, physicians who in good faith give such help or advice to a married person to cure or prevent disease are exempt. Disease, by Webster's International Dictionary, is defined to be an alteration in the state of the body or some of its organs, interrupting or disturbing the performance of the vital functions, and causing or threatening pain and sickness, illness, sickness, disorder. The protection the physician afforded would also be extended to the druggist or vendor acting upon the physician's prescription order. Now, when we think about pregnancy, especially those women in the room who've had morning sickness, one could actually characterize pregnancy as a alteration in the state of the body resulting in pain and sickness, disorder, etc. It results in a wonderful outcome, but one of my daughters has 24/7, 9 months of morning sickness, so it would fall clearly within the sort of definition. In this way, though, the court expanded the statute that was intended to allow distribution of contraception only to combat sexually transmitted diseases to include any circumstance where, in the physician's judgment, it was necessary to promote the woman's health. We're going to revisit that when we get to a case about abortion, Doe versus Bolton. The other thing it did is the exemption in the statute was strictly provided only for physicians, but the court interpreted it to encompass pharmacists and vendors, a drive we're seeing in other countries where they're trying to avoid any medical involvement beyond or any physician involvement and allow over-the-counter distribution of contraception. So we see the seeds of this in 1918 in the People versus Sanger. It's important to note that that was a New York opinion. It didn't extend beyond the boundaries of New York, and that this was a topic that was being debated and litigated throughout the country. So you see that in Tilston versus Ullman, a Connecticut opinion, as late as 1942, the state Supreme Court declined to create exception for the use of contraception, even where the woman's life was in danger or threatened by the pregnancy. The court reasoned that because there had been multiple attempts to alter the statute through legislative means, and in each time the legislature refused to make the alteration, that it represented the will of the people and their elected representatives, and it simply wasn't the court's job to rewrite the law, even under these circumstances. So there was a healthy political debate going on among the states about what exemptions should be allowed for the distribution of contraception, at least through physicians. Well, Margaret Sanger, regardless of her actual ultimate goals, was truly a remarkable and effective woman, for good or for ill. In 1921, she establishes the American Birth Control League, the antecedent to Planned Parenthood Federation of America. And in 23, she successfully opens the first legal birth control clinic in the U.S. with the stated intent of using only contraception for medical purposes, such as the prevention of life-threatening pregnancies, in accordance with the Crane decision, the decision we were talking about just a few minutes, Sanger versus the People. So again, her beginnings were largely motivated by her experience, particularly with poor women in New York City and in Brooklyn. And so she really believed that pregnancy was at least something that accompanied poverty or exacerbated poverty, and that this was an important health campaign that she was engaged in. Now, simultaneously with this, and I would love to hear a lecture by Dr. Condick about sort of the development of our whole understanding of human reproduction, because we tend to forget that in the early 1900s, we really didn't understand much about a woman's body during pregnancy or about the nature of pregnancy. Frankly, even today, I think there's a lot of truth in that when we look at sort of the medical research being done. And one of the great gifts of natural family planning, Hilger's Institute and all of the other organizations that further that goal, is the fact that they take women's health really seriously. They're doing unusual research that you don't find in the major medical institutions, which predominantly devote themselves to other things. They really want to know how our bodies work, as opposed to simply medicating them or creating devices that will make our bodies work differently. It's a great blessing. So even as late as 1920, scientists working independently in Japan and Austria devised the rhythm method of birth control. After figuring out that women were fertile approximately midway through the average menstrual cycle, they concluded that pregnancy could be avoided by abstaining from sex during that fertile period. Now, those of you who have studied natural family planning know that we are far advanced beyond the rhythm method. But the fact that it wasn't until 1920 that we understood that periodic abstinence would actually allow the couple to plan and space their children explains a lot about sort of the history of regulation and the efforts in this area. In 1927, there was a famous case, Buck v. Bell, in which the United States Supreme Court held that the state could sterilize the feeble-minded. In fact, in a very famous statement by Justice Holmes, he said that 3 generations of idiots is enough. Minnesota was very active in the eugenics movement, and this was part of the eugenics drive, was the sterilization of those who were described as feeble-minded or lunatics. Now, in fact, Becky Bell was a 3rd-generation occupant of a mental health facility, but she herself, at least evidence seems to suggest, was perfectly competent, but her abilities were limited by the environment in which she had been raised. She had a child, and the superintendent of the institution found that inconvenient, as one might expect in an institution, and therefore they were concerned that she was going to get pregnant a 2nd time, and they ordered her sterilization after a hearing. The Supreme Court upheld that, and even until today, Buck versus Bell is still the law of the land. It is still constitutionally permissible under limited circumstances for the state to order the sterilization of an individual. At least the court has never reversed that opinion. In 1930, not to take us off topic too much, but to show that the culture was changing from 1873, when we could pass the Comstock Act, when there was a consensus that contraception, sex-related paraphernalia, obscene literature, etc., should be controlled and in fact discouraged through national legislation. In 1930, at the Lambeth Conference, the Anglican bishops adopted Resolution 15. It's the first break we see from the universal Christian approach to what was called birth control. Where there is clearly felt moral obligation to limit or avoid parenthood, the method must be decided on Christian principles. The primary and obvious method is complete abstinence from intercourse for as long as may be necessary in a life of discipleship and self-control lived in the power of the Holy Spirit. Nevertheless, in those cases where there is a clearly felt moral obligation to limit or avoid parenthood, and where there is a morally sound reason for avoiding complete abstinence, the conference agrees that other methods may be used, provided that it is done in light of the same Christian principles. The conference records its strong condemnation of the use of any methods of contraception for motives of selfishness, luxury, or mere convenience. This reflected a dramatic shift in culture's view of contraception and divided Christendom on this issue. Now the Protestants accepted it, at least in cases where there was a serious moral purpose for using artificial contraception. The Catholics continued to hold to the principles that they had endorsed. In 1936, we saw the federal legislation. Remember that the case with Margaret Sanger was only the New York statute that was under attack. In 1936, we see the federal statute prohibiting the distribution or sale of contraception through U.S. mails or through interstate commerce. In this case, the Comstock prohibition of using mail or interstate commerce to promote the sale of contraception is reinterpreted to allow shipment to physicians in a case over the shipment of Japanese diaphragms to a doctor in the U.S. The court rules that physicians can receive contraceptive devices and information via the mail unless prohibited by a specific local law. So the federal law creates an exception for state and local ordinances, but upholds the ability to use the U.S. mail or to transport these items across state lines. This facilitates recognition of birth control as a legitimate part of a doctor's medical practice, which then was embraced by the American Medical Association. I cannot tell you how important the medical associations are in the development of this law as well as the law of abortion. Those of you who are doctors, I beg you to stay active in your professional organizations, as hard as it is, and believe me, the American Bar Association ain't any better. But the simple fact is, in every case where the American Bar Association has stayed out of the fight, we have won in the U.S. Supreme Court. In every case where the American Medical Association has filed a brief in favor of abortion or in favor of contraception, we have lost. It matters to the court what the medical associations think. I believe the only reason we won the assisted suicide cases is because the AMA stayed out of it. That's why it's so important that you be involved, particularly now where various medical professional associations are reevaluating their opposition to physician-assisted suicide. Separate topic, but an important and related topic. The FDA approved the use of Envoid for the treatment of severe menstrual disorders and requires that the drug label carry a warning that it will prevent ovulation. Well, people aren't dumb. They know what that means. At the same time, in 1942, continuing the eugenics drive, the Supreme Court struck down an Oklahoma statute that directed sterilization on repeat offenders of the criminal law. In this case, the man had engaged in check kiting, writing checks from one account while transferring funds, etc. So it was a financial matter, but nonetheless, because it was his third conviction, the Oklahoma law would have required sterilization and a belief that criminality was transferred by blood, an old concept that we found in the common law. And even today, if those of you who have read Freakonomics, where the argument is made that part of the decline we've seen in crime is because of the increased abortion among certain segments of society, it's a bad idea that doesn't die easy. In 1959, President Eisenhower there was enough of a consensus in this country regarding sexual morality that he states at a press conference that birth control is not a proper political or government activity or function or responsibility, and adds emphatically that it is not our business. 1959. Less than 2 years after the FDA approved the use of Envoid, however, for therapeutic purposes, the unusual number of American women mysteriously developed severe menstrual disorders and asked their doctor for the drug. By late 1959, over 500,000 women were taking the drug, presumably for the off-label contraceptive purposes. I found this particular medical article fascinating. Alan Guttmacher, of course, is a physician who was active and ultimately president of Planned Parenthood International. And he was an obstetrician gynecologist practicing in New York at Mount Sinai Hospital, a very prestigious hospital at the time. In his research regarding a comprehensive review of available contraception, he writes, if there were an infallible, simple, effortless method to pinpoint the hour of ovulation, and one could make sure that the patient in question never ovulated more than once a month, the rhythm technique would immediately become the world's ideal contraceptive. 3 years later, he ascended to the leadership of Planned Parenthood Federation, and in '64, he became the president of the international organization. I find this really interesting because, in fact, he's endorsing this because if there is a method of the spacing and timing of children that is good for women physically, that doesn't involve the introduction of drugs or foreign devices into their body, even Guttmacher recommended that that would be far superior to what we're doing today, especially to our young women. In 1961, the battle over contraception and state laws came to the Supreme Court, and we actually won that case insofar that the court had under consideration the Connecticut statute, which prohibited the use or sale of contraception. The court ultimately dismissed the case because there was no case or controversy. In other words, what the court learned during the briefing is that while Connecticut had the law that prohibited use of contraception since 1879, there had not been any prosecution in the intervening 75 years except for one test case, and that had actually been dismissed by the state ultimately. The court noted that contraceptives are commonly and notoriously sold in Connecticut drugstores, yet no prosecutions were recorded, and certainly such ubiquitous, open, public sales would more quickly invite the attention of enforcement officials than the conduct if it were present appellates wished to engage. In other words, get out of our courtroom. You're trying to change the law via the courts, go to the legislature. This is a fake case. 1961. Unfortunately, just 4 years later, the court took a different position. Same law, same lack of prosecution, same lack of real case, and yet in this case, the court reached out and struck down the Connecticut statute as unconstitutional under the right to privacy found in the Due Process Clause of the 14th Amendment. That particular ruling was grounded in the idea that marriage is a unique association. The court characterized it as more significant than any other association found in society. It talks about the privacy of the couple to make their own decisions about their family within the privacy of the bedroom. And yet, they strike it down in 1965, grounded on this marital privacy concept. In the same year, the President Johnson, however, declares that the federal government would seek new ways to use knowledge to deal with the explosion of world population and growing scarcity of world resources. What we see in President Johnson's comment is something the exact opposite, of course, of President Eisenhower, and is a product of the shifting justification being offered for the widespread availability of contraception. What began with Margaret Sanger as a desire to promote women's health that morphed, at least in part, to a genetic eugenics idea that was to promote healthy human stock. After World War II, when we saw the German experiments, that died in popularity. But the new argument coming after World War II is that it is necessary to ensure a world safe from overpopulation and the threats to national security that would derive from overpopulation. The Rockefellers were very active in promoting this concept and funded a great deal of international activity. President Johnson says, we're going to get involved in this. So it becomes the policy of the U.S. government to involve ourselves in what we consider a growing explosion of the world population. All of this suggests to me that the Holy See was a little late coming to address this issue, sadly. In 1968, it was when Humanae Vitae was issued by the Vatican, but our government had already chosen to be involved. For years, states had provided public funding for poor women to use contraception. We were beginning to provide international funding to ensure contraception was promoted in foreign countries that had developing populations. And in that same year, largely overshadowing the issuance of Humanae Vitae, at least throughout the culture as a whole, was the publication of The Population Bomb by Stanford professor Paul R. Ehrlich. He warned of mass starvation in the 1970s due to overpopulation, arguing that there were few immediate actors that could foresaw the disaster in most of the world. The Population Bomb was a bestseller, and it influenced public policy tremendously, notwithstanding that all of his predictions have proved to be false, and largely echoed those of Malthus, an economist in the 1700s in England, who also said that we were all going to starve to death if we didn't start limiting population. Another bad idea that simply won't die. The USAID began purchasing contraceptives to distribute to developing countries. Robert McNamara, as president of the World Bank, announces that population control will be an element of review for loans. You need a new network of dams in order to irrigate your fields in a foreign country? Fine, show me your population policy and maybe we'll give you a loan for the dams that you need to build, or the hospitals, or the roads, or whatever other public infrastructure you need. In 1970, the passage of Title X went through Congress. It's a Public Health Service Act, which establishes the program to offer low-income women certain reproductive health services, including family planning, as well as non-directive pregnancy counseling and referrals on all options, including abortion. By law, abortion may not be treated as a method of family planning in the program, but referrals are mandated by the Public Health Service guidelines governing the program. They themselves cannot do it, but they have to have a neutral, even-handed representation of all the options facing a woman who is pregnant. In 2017, according to the most recent report, 17% of the recipients of family planning services under this law are teenagers aged 19 and below, 17%. And while counselors are encouraged to include family involvement in the decision of minors, Title X projects may not require written consent of a parent or guardians of the provision of services to minors, nor can any Title X project staff notify a parent or guardian before or after a minor has requested and or received Title X family planning. In other words, any girl in any state can go to a Title X family planning agency, aka Planned Parenthood and a few other clinics, request contraception, be told that she should involve her parents, but if she chooses not to, they will provide the contraception to her without notifying her parents, which they will then proceed to do. If she has private insurance, they will advise her not to use it because her own income level will put her poverty status, and that way there will be no notice from the insurance company to the parents that their insurance has been used in this matter. 17% of all of the recipients, 19 and under. The Supreme Court became very active on this issue in the 1970s. In 1972, we have Eisenstadt v. Baird. That's the case where the U.S. Supreme Court, based on its prior decision of Griswold versus Connecticut, recall that decision was grounded on the right of a husband and wife to make that most intimate decision within their own bedroom without undue influence by the government. In this case, the court said, well, single people should have the same rights as married people. Marriages aren't anything other than two individuals that have separate views and separate ideas. And so, in fact, they found a constitutional right of single people to access contraception, notwithstanding that were state laws that forbade the sale of contraception to single individuals. And in 1973, Roe versus Wade and Doe versus Bolton were covered. 1973, of course, is a watershed year. Most of you know Roe versus Wade, of course, struck down all of the abortion regulations throughout the country, notwithstanding that we had a broad public policy debate. There was actually a referendum in the state of Washington where the abortion laws had been reformed to include access to abortion in the first 2 trimesters. However, it was conditioned on husband consent and parental consent in certain instances. We know that New York had legislation that allowed access to abortion. Hawaii had legislation. Notwithstanding that, the court felt compelled to enter into what was being contested and debated in every state capital in the Union and ruled that the Constitution, through its penumbra surrounding the Bill of Rights, gave a woman and her physician the right to make the decision to terminate a pregnancy. That's the opinion we all know. Doe versus Bolton, if you're active in the pro-life movement, you also know. It's a companion case where the question was whether a statute that required double physician approval prior to an abortion for health purposes should be interpreted with the broadest possible definition of health. In fact, the court said that health includes the economic health of the woman, her age, her familial status, all sorts of non-physical and medical considerations in that instance, which has led pro-lifers to accurately say that an ill-defined health exception in any prohibition of abortion simply becomes the right to have the abortion. One abortion provider who had written the first textbook for medical schools on abortion testified in front of Congress that any woman who is distressed by her pregnancy has a psychological health problem that must be addressed by access to the abortion. This is the reason we can say accurately that an ill-defined health exception essentially will swallow the rule of prohibition. In 1914, just 15 years after President Eisenhower had declared that birth control is not the government's business, the government supports birth control clinics in almost 2,400 of the nation's 3,099 counties. Of all the methods dispensed, at this time the pill is the most popular. In 1977, the U.S. Supreme Court again rules that access to contraception must be made available to teens without parental consent in certain circumstances, striking down a parental consent statute that was in effect in Massachusetts at the time. The 1980s were a little better for us. In 1984, at the International Conference for Population held in Mexico City, President Reagan announced that there must be U.S. neutrality as far as population growth, reversing the policy of Lyndon Johnson, and that We have opposition to abortion as a means of family planning. This is very important as we continue to battle in the United Nations. Just this year, the World Health Organization, with no treaty authorization, has defined abortion as a method of family planning and addresses it as such. In 1985, the Kemp-Kasten Amendment prohibited U.S. funding for any entity that supports or participates in the management of a program of coercive abortion or involuntary sterilization as determined by the President. That, of course, was addressing the situation in India and China with the one-child policy. India went for a period under Indira Gandhi where there was forced sterilization and abortion as well. As a result of those two programs, they received a United Nations Population Award, the first year it was ever awarded, for their diligence in controlling population growth. Starting with Ronald Reagan, every Republican administration, including the present administration, has used the provision of the Kemp-Kasten Amendment to defund the United Nations Population Fund in supporting coercion in China. Sorry, I'm not sure what happened here. Let's see if I can. Thank you, Bill, if you can pull us back. This is the most chilling explanation of the relationship between contraception and abortion. In 1992, in what is called a plurality opinion, an opinion in which a majority of the justices can reach a common result but cannot explain the result with a common reasoning, the court upheld a Pennsylvania abortion statute refusing to overturn Roe versus Wade. In it, the plurality opinion, and there is some evidence that Justice O'Connor authored this particular provision, states, abortion is customarily chosen as an unplanned response to the consequence of unplanned activity or to the failure of conventional birth control. And except for the assumption that no intercourse would have occurred but for Roe's holding, such behavior may appear to justify no reliance claim. In other words, if we reverse Roe today, no one, at least 9 months out, can claim that they were relying on the availability of abortion in making their decision to have unprotected sex or sex with failed contraception. The court rejects that argument, however, saying, to eliminate the issue of reliance that easily, however, one would need to limit cognizable reliance to specific instances of sexual activity. But to do this would be to simply refuse to face the fact that for 2 decades of economic and social development, people have organized intimate relationships and made choices that define their view of themselves and their place in society in reliance on the availability of abortion in the event that contraception should fail. The ability of women to participate equally in the economic and social life of the nation has been facilitated by their ability to control their reproductive lives, and the Constitution serves human values. While the effect of reliance on Roe cannot be exactly measured, neither can the certain cost of overruling Roe for people who have ordered their thinking and lives around that case be dismissed. We have to maintain constitutional limitations on prohibiting abortion because we have to make sure that when contraception fails, people have access to abortion. Justice O'Connor could not be clearer. She also makes an argument that as a woman, I find deeply troubling and is part of the reason I'm so grateful for the work of Siena Symposium. The argument that it is legitimate and permissible for society to limit our participation in the marketplace, in the economy, in the public square, on the fact that we must have the same reproductive lives as males. We must surrender our fertility and our capacity to bear children in order to gain admission to the public square. That cannot be the law. Fast forward then to the most recent fight. Not satisfied that individuals had access to contraception, both through Title X and through their own private medical insurance in most cases. In 2010, the federal regulations under the provisions of the Affordable Health Care Act of 2010, some of you know it as Obamacare, imposed a federal contraceptive coverage guarantee which applied to most private health care plans nationwide, whether sold to employers, schools, or individuals, or whether offered by employers that self-insure. An employer that self-insures shoulders the financial risk of health care costs for all of its employees. State laws cannot regulate self-insured employers, which cover about 60%. The bill was also riddled with a number of other exceptions which became relevant in the litigation that we know as the Hobby Lobby case in Burwell versus Hobby Lobby stores. In that case, a group of private employers who were not nonprofits went to the court arguing that because they had objection not to making contraception available through their health care plan, but simply making abortifacient contraception available through their health care plans, violated their religious freedom rights. The court, in a fractured opinion, held for Hobby Lobby and the Green family, as well as Costanoga Woods and the third plaintiff in that case, all private employers, on the basis that a federal statute, the Restoration of Religious Freedom Act, required that the government show a compelling state interest in forcing private employers to provide this coverage, and that the means that they did so was the most narrowly available. The court recognized that, in fact, if the government felt compelled to make sure that contraception was available to every woman of reproductive age, it could simply fund it and extend Title X with no income limitations. Therefore, they held for the employers that instance. However, in 2017, I apologize, this is way too small. It's too small for me, so I'm going to turn to my print copy. But in 2017, what we see is that a number of states were also regulating in this way. And so the Trump administration made it much easier for employers to exclude from coverage any health plan if it offers to its employee and their dependents. One regulation also allowed health plans if sponsors of the employer had religious objections. Another regulation allows employers with moral objections to do the same, although it applies with a slightly narrower set of criteria. They also diverted the funding to the UNFPA, to the State Department's Global Health Program, which funds programs only that do not promote or provide abortion. So we've gotten both court relief, and now we have even broader relief by regulation under the current administration. In 2018, according to the most recent Kaiser study, Kaiser Health study, 29 states require insurers at a state level to cover prescription drugs that provide coverage of FDA-approved prescription contraceptive drugs and devices. That includes the Ella and other prescriptions that are demonstrably abortifacient, at least in certain instances. 8 states do not permit refusal by any employers or insurers. Not the church, not religiously affiliated organizations, not any employers in those states. California and New York are among them. Because they are state laws, they are not subject to the Federal Restoration of Freedom Act, which was the basis of the Hobby Lobby opinion. Therefore, relief can only be found in the state Supreme Courts, which have been denied both in the California Supreme Court and the New York Supreme Court. California's imposed a new requirement that ensures that employers include induced abortion within their insurance coverage. We're in the process of litigating it, but do not hold out much hope through the California courts. There is federal regulations and legislation that may provide relief under the new Department of Justice, but under the previous administration, they failed to find any violation of the regulation, although it expressly stated that you could not force insurance to include induced abortions. New York and Washington State are also considering broad requirements for the funding of abortion. The government is deeply involved in contraception. They have declared that it is good public policy, and the court has indeed participated with them in ensuring that there is very little that can be done other than through the political process. It's important then to recognize that Pope Paul was correct when he said that governments will get involved in the most intimate decisions of husbands and wives if, in fact, artificial contraception is included. We now see, clearly at least in the American society, not only will they get involved through the use of contraception, but it will lead to the endorsement and facilitation of abortion. Thank you.